Hey everyone, Michael Strickland back here with another one of these first-person video commentaries here. For those of you who are new to the channel, who haven't seen any of my other videos, I was the video news journalist who was out covering a protest on the evening of July 7th, 2016, when I found myself being attacked by a mob of masked protester thugs. I acted in self-defense to prevent them from beating and robbing me, except I was the one who got arrested. I was the one charged and eventually found guilty of 21 counts of crimes, when the violent thugs who started the fight are considered to be the poor innocent victims. So as I continue to fight my case on appeal and beyond, I've started this series here of first-person videos, just giving some commentary of interesting things that have come across the way here. For today's video, as I've been studying these various different case laws that have related specifically to self-defense over the years, I came across one ruling in particular that I found quite fascinating. In 2009, the Oregon State Supreme Court took up the case of State versus Oliphant. Now, this was a case that comprised of 3 defendants. There was Oliphant, Relatos, and Wood. Now, they were each charged with a variety of different crimes and eventually found guilty of things like disorderly conduct, resisting arrest, assaulting an officer. They appealed their convictions, which the appeals court upheld, but the state Supreme Court eventually overturned one of the convictions, and that was the conviction of Kenneth Wood. And the state Supreme Court ruled that he acted in self-defense against the police. Well, that's a little odd. Well, in Oregon, police officers can only use the minimal amount of force necessary to bring a subject into custody. Any force above that is then, by default, an unlawful use of force. And according to Oregon self-defense laws, one is justified in using force to defend themselves against what they reasonably believe to be unlawful physical force or the imminent use of unlawful physical force against them. In this particular case, the Supreme Court ruled that Kenneth Wood did indeed reasonably believe that the officers were using unlawful physical force against him, and thus he was entitled to self-defense against the police. Now, I'll get into how this affects my case here. This specifically relates to the mindset of the person who is citing self-defense. For example, some of these quotes out of the Supreme Court's ruling says, "The preliminary consideration relevant to the question of the defense right to use of force in self-defense was the defendant's reasonable belief in the necessity of using force, not the officer's belief." Wood contends that a defendant may use force to defend himself against what he reasonably believes to be an officer's unlawful use of force against him, whether that officer's use of force was actually unlawful or not. The plain wording of the statute thus establishes that, in general, a person's right to use of force in self-defense depends on the person's own reasonable belief in the necessity of such action, and not whether the force used or is about to be used upon him was actually unlawful. Now, they also cited a prior case, State versus Wright, W-R-I-G-H-T, which I believe was in 1979, and they said that it is not the intent of the assailant which harms the one he attacks. Neither is the latter bound by it, nor required to ascertain it. It is the imminent danger, real or apparent, of great bodily injury to himself, which justifies a defendant in protecting himself. Now, all of this kind of circles back around to the situation that I found myself in, where I reasonably believed that unlawful force had just been used against me, and I was on the retreat to get away from any further physical force, and these people continued to bear down on me, and I believed when it had reached a point where they were converging on me from multiple different angles, and the big guy who started the entire thing, who's literally twice my size, is coming up on my blind side at that point. I believed that further physical force against me was imminent at that point, so I drew. Again, if you're new to this channel, there's plenty of other videos on my channel that detail and describe exactly what had happened using multiple different video angles of the incident in question. Now, this is all important as it relates to my case because Judge Thomas Ryan ruled that my statements to the detective that related to my state of mind were inadmissible. And that's one of the issues that we've brought up on appeal. So how can we then, if the judge is not allowing that stuff to be admitted, how can we then establish what my mindset was at the time when I acted in self-defense? But State versus Wright, they said, if a police officer uses excessive force in making an arrest, the arrestee has a right to use physical force in self-defense against the excessive force being used by the officer. In that circumstance, the arrestee is not resisting arrest, but rather defending against excessive force being used by the arresting officer. Thus, while the actual lawfulness of the officers, back to the Wood case here, of Gulberson and Miller's conduct might in some way be deemed pertinent to assessing those officers' own culpability, that subject is not a consideration respecting Wood's right of self-defense. If Wood believed, and a reasonable person in his position would have believed, that the imminent use of physical force against him exceeded the force reasonably necessary to effect the arrest, then he was entitled to defend himself. Wood was entitled to his right to self-defense of what a reasonable person in his position would have believed was occurring. What the officers believed was not, and indeed could not have been, any part of Wood's state of mind. So what was going through my mind in my situation is the only thing that's relevant when I'm citing self-defense. What Carenza, the big guy who started the altercation, what his intent was, what the other people's intent were, is irrelevant. It was what I interpreted their intents to be at that point in time. So let's also take a look at what is considered a threat to a police officer and juxtapose that with the situation that I found myself in. Now, evidence showed in the Wood case, evidence showed that Officer Gulbranson called for Code 3 backup before he even got out of his cruiser. Now, Code 3 means an officer is in dire need of backup because of an injury or threat to the officer's life. But he called for this when the only subject at the time was Relatos, a female. So according to the police, one female shouting obscenities at you is an injury or a threat to an officer's life. Now, in the Wood case, an expert testified on behalf of the state against Wood that the officer's actions against Wood were, quote, reasonable, given that Wood presented an ominous threat to Officer Gulbranson, insofar that Wood did not obey Gulbranson's request to stay over there. He had his chin lowered as he walked, and he appeared to quicken his pace as he approached Gulbranson. And Gulbranson knew that Wood had a reputation for violent and resistive behavior. Gulbranson said, and the way he was approaching me, I was getting very nervous to the point of, he was taking steps of the sign of aggression towards me. Now that's interesting, juxtaposing that onto my case, because here you have one person versus an officer, and the way that Wood was presenting himself was now somehow justified to the police as a threat towards the officers. Yet juxtaposing that to how the actions of Benjamin Carenza and all these other people are coming up, running up against me, that's somehow not considered threatening behavior now? So according to the documents, this officer in the Wood case, Officer Gulbranson, stands 6'3" and weighs 260 pounds. It's a pretty big dude. The officer testified that before the contact became physical, he felt that he had to figure out which the bigger threat was between the subjects at that point, who were Sissy Relatos, a female, and Kenneth Wood, who stands about 5'10" and weighs about 170. So according to this case, those people acting in the way that they were explained by the expert witness were a threat to the officer. But in my case, when you have 7, 10, 12, 15 people with masks over their faces, some of whom are much larger than me, shouting obscenities at me, pushing me around, manhandling me, as one witness stated, that is somehow not considered a threat now? So Wood continued walking towards Officer Gulbranson with a strong, powerful stride before Gulbranson tried to arrest him. So one person doing that to a large officer is considered a threat worth immediately addressing. But 7 to 12 to 15 people doing that against a single citizen is not a threat, according to the courts. So to sum this up, it is legal in Oregon to physically fight police officers if you reasonably believe they are using beyond the minimal amount of force required to bring you or someone else into custody, as you are then acting in self-defense or the defense of another. But according to the courts, it's also not legal to act in self-defense when you are physically attacked in the streets by a mob of masked thugs when you are engaging in your First Amendment right to free press. Now, some of the things that I've said here are a little tongue-in-cheek. You know, I'm a little sarcastic when I talk about what the courts have ruled in relation to my case here, because of course my actions were in self-defense. What I've explained through most of this video is not necessarily my own viewpoint, specifically as it relates to the Wood case, or, you know, what officers go through, what officers believe, what Kenneth Wood believed, what the judges said. So what you or I think should and shouldn't be legal really doesn't matter. We're just peons. It's all about what the judges rule, what the DAs argue, and what the police say. I'm merely explaining what has been ruled in the past and what has been determined to be legal or illegal, lawful or unlawful, and what someone has a right to do and what to not do. I feel that it's important to get that kind of information out there because I hate to see anybody else have to go through what I've gone through over the last 2.5 years coming up on now. And, you know, it's interesting. I never would have found this case had I not had reason to research all of these past case law decisions that relate to self-defense. So in the next episode, we're going to tie the Wood case into Gresham police officer Ryan Rasmussen's testimony during my trial. Other police officers are not going to be very fond of what Officer Rasmussen had to say.